So the conservatorship of Britney Spears, it's certainly salacious, it's in the news, but actually that case had a profound impact on conservatorship law, and the California legislature changed the laws around conservatorship in order to make it more difficult to have a conservator appointed, to make it easier to terminate a conservatorship, to give the conservatee the right to pick their own attorney, instead of having the court appoint somebody for them. A lot of changes to the law occurred as a result of what some people thought was an abusive conservatorship. And so a question around that, is how did Britney Spears get conserved? How did her father become the conservator? What were the parameters? What was the court doing to look at it? There are three kinds of conservatorships that exist. There is a general conservatorship. A general conservatorship is for people who are unable to resist undue influence or fraud. They can't manage their own financial affairs. If they have a conservator of the person, that means that they can't provide for their own food, clothing, and shelter. They can't provide for their own medical care. That's one type. In general, we see seniors who have dementia. That's a very common person who would have a conservator in that context, a general conservatorship. That is what Britney Spears had. She had a general conservatorship, and her father was the conservator of her person. He was allowed to make her healthcare decisions and decide where she lived. And there was a conservatorship of the estate. He managed her financial affairs. The second kind of conservatorship is a limited conservatorship. A limited conservatorship is a conservatorship for someone who is developmentally disabled. Usually they are a client of the regional center in their county, and now that they have reached age 18, their parents usually will apply to become the conservator of their developmentally disabled child. The third type of conservatorship is an LPS conservatorship. An LPS conservatorship is for someone who is gravely disabled. Gravely disabled people's primary diagnosis is a mental health condition or a drug issue. And the only person who can apply to be an LPS conservator, the only person who can start the case, is the county in which the person resides. That's who has the power to do it. An LPS conservator is the only person, and that conservatorship can only last for a year without having for the county to apply to be reappointed. An LPS conservator is the only person who can get legal authority to give medications to treat psychological illnesses, psychiatric illnesses. They can do things as extreme as give people electroshock therapy against their will. But they can also force people to take drugs for the treatment of psychiatric illnesses. And that is the county has to do that. So the question in the Britney Spears case, Britney Spears has alleged that she was forced to take psychiatric medications against her will, that happened, but she was in a general conservatorship. We haven't seen the pleadings, so we don't know what the basis for the conservatorship was, but one can presume that some of the basis was that she was experiencing a mental health crisis, a psychiatric crisis, and that the basis for that conservatorship should have required it to be an LPS conservatorship with the county being in charge of it, and it only lasting for 1 year until the acute psychiatric crisis, 1 year or less, until the acute psychiatric crisis had resolved itself. What we had instead was Britney Spears' father applying for a general conservatorship, allegedly forcing her to take psychotropic medications for a person whose primary diagnosis was psychiatric. And so there are a lot of questions about how that type of conservatorship was applied to somebody with that diagnosis. And I meet with families very regularly who are in absolute distress because they have a family member who is schizophrenic or bipolar or has a primary diagnosis of a mental health disorder, and they are at a loss because they would like to force that person to take medications to treat that, but they can't get court orders that would allow them to do it. So there are a lot of things that are unknown about the Britney Spears case. There is a document that gets filed in a conservatorship called confidential supplemental information. And in that confidential document, the court has a confidential file where they have information about the conservatee's medical record, evaluations of the conservatee by their doctor. That's all in a confidential file, and rightfully, the public hasn't seen that. It's confidential, sensitive, private information. But in those documents, it would say what was the basis, the allegations that were made in order to bring this conservatorship forward. As with anything, a question for attorneys who practice conservatorships, who bring those cases and represent people in conservatorships, were the legal changes made after the Britney Spears case came to light helpful or harmful? Have we thrown the baby out with the bathwater? Have we made it so difficult now to get a conservatorship that we aren't able to help the people who need them? And so these changes to the law are relatively new, and we'll have to see how they play out. But certainly her conservatorship has had more than, it's more than just newsworthy. It has had a lasting and profound effect on the actual law in the state of California.
Hey guys, it's Attorney Amy. I hope you liked that video. For more content like this, please remember to like and subscribe and hit that notification bell. I post content weekly. If there's topics or issues you think I should cover, please let me know in the comments.